To order. Good morning, everyone. I want to thank you for coming to today's hearing. I will begin this hearing by recognizing myself for 5 minutes for the purposes of an opening statement. This hearing is on the bill H.R. 1706, the Protecting Consumer Access Generic Drug Act of 2009. Today's legislative hearing is on a bill that Congressman Waxman, Chairman Waxman, and I introduced last Congress. And this subcommittee held a legislative hearing on our bill on May 2nd, 2007. We have introduced the bill again with the intent that it becomes law. H.R. 1706 bans what are known as exclusion payments, reverse payments, or reverse consideration in patent settlements between name brand and generic drug companies. This is a practice in which the brand name company pays or provides value to the generic company, and the generic company agrees to delay the marketing of its generic drug product. First, the bill is fully supported on a bipartisan basis by the FTC. The Commission believes that a legislative fix is needed because the courts have thwarted their enforcement efforts. Both Republican and Democratic chairmen and commissioners have historically supported congressional action cracking down on these uncompetitive settlements. This is not a partisan issue. Second, the bill does not ban all settlements in all patent cases. Quite the contrary. H.R. 1706 only bans exclusion payments in legal settlements. Brand name and generic companies are still free to settle their differences. In fact, because the court invalidated the FTC's enforcement efforts, before the courts invalidated the FTC's enforcement efforts, drug companies were settling their patent disputes without any exclusion payments. It wasn't until the court struck down the FTC's enforcement action in 2005 that these very unique type of settlements came back from the dead. Third, these types of settlements were completely unique to the drug industry. They do not appear in any kind of patent dispute other than this drug industry. In all other patent disputes, litigants settle in two ways. One, the enforced or the accused infringer pays the patent holder a royalty to market its products, or two, the parties agree to an early entry date. Only in the drug industry do we see the unusual behavior of a patent holder, which is a brand name company, suing the accused infringer, the generic company, and then settle by paying the infringer to stay off the market. These unique settlements are the result of the equally unique regulatory framework of Hatch-Waxman. And I don't believe that the drug companies are acting in bad faith. I believe that they are perfectly logical under their fiduciary responsibility, under their fiduciary duties to their shareholders. They're being responsible, and they are simply responding to the incentives they face under Hatch-Waxman. Lastly, H.R. 1706 will save taxpayers, businesses, and consumers tens of billions of dollars. That is the ultimate purpose of this bill. Congress is currently considering ways to save money in order to provide affordable health insurance to all Americans. I believe that H.R. 1706 can play an important role in reducing prescription drug costs in our economy. We cannot afford to do nothing on this unique, uncompetitive way of doing business that costs consumers billions of dollars. I want to thank our witnesses for appearing before this committee in this first step of the legislative process. And I want to now yield back the balance of my time. And now I want to recognize the ranking member of the subcommittee, my friend, Mr. Stearns from Florida.
Good morning, and thank you, Mr. Chairman. I'm glad we're having this hearing on H.R. 1706, Protecting Consumers' Access to Generic Drugs Act. On this side of the aisle, we perhaps see this bill a little differently. We see it as a solution looking for a problem. The Hatch-Waxman Act of 1984, we think is working, and we're not sure. Maybe a little bit of steering might be implied, but not necessarily eliminating, and with a brand new bill with this H.R. 1706. You know, when you look at the history of the availability of generic drugs over the past 25 years, which have helped millions of people live healthier lives and, most importantly, reduce the cost of health care, in the face of ever-increasing health care costs for families, I asked my staff to pull up some statistics. And since the Hatch-Waxman passage, the generic industry's share of the prescription drug market has jumped from around 19% to over 70% today. So again, I say, let's be careful, do no harm. It's clear that the Hatch-Waxman Act and current practices have been successful in bringing low-cost alternatives to families and to the market. So I do have a few concerns which I'll outline here. This bill addresses two facets of the generic pharmaceutical trade. Reverse payment settlement, which I'm going to use the word payment settlement. I notice the chairman used the words exclusion payments and reverse payments, but I think the actual term, which is payment settlements. And the other issue is the 180-day exclusivity period granted to first filers under the Hatch-Waxman Act. This latter consideration is really there as an incentive for generic drugs who take the risk to sue. So I'm not sure that it should be changed. Now, opponents of the payment settlement argue that this practice delays the introduction of generic drugs to market and permit drug innovators to continue their patent protection and market exclusivity, even if it is for a shorter period of time than the patent allows. In reality, though, the opposite is true. These settlements often bring drugs to market sooner than would otherwise be permitted by the completion of the brand drug's patent. Critics also argue these settlements encourage patent challengers to abandon their claims in litigation when an alleged 70 to 80% of challenges succeed. This statistic can be misleading and does not take into account that while a challenger may win on 4 out of 5 claims, it is the invalidation of just one of those challenges that is necessary to prevent the launch of a generic drug. Now, according to recent studies, the success rate of challenges that lead to the early introduction of a generic drug is actually closer to 45%, not the 70% that people talk about. Furthermore, patent litigation is expensive, unpredictable, and can last for many years. The emphasis in patent litigation is in any other litigation area is to settle. In many cases, it is a win-win situation. The brand company wins by saving money on protecting its patent. The generic company wins by saving money on litigation expenses and gaining earlier market entry. And the consumer wins with early access to a less expensive generic product. Now, unfortunately, this legislation that we're talking about this morning would outlaw anything of value to be exchanged in a patent settlement. Therefore, an innovative drug company would have no incentive to do anything but defend its patent till expiration, inadvertently creating a chilling effect on early generic drugs introductions, which the consumers would enjoy. Given this reality, generic companies could be discouraged from investing capital in patent prosecutions until it is assured of a success, a virtual impossibility in any patent litigation scenario. If longer drawn-out litigation was not enough of a disincentive to challenge a patent, eliminating a generic company's ability to recover its litigation costs through the 180-day exclusivity period is enough to put the final nail in the casket of generic challenges. As a carrot to encourage patent challenges, the Hatch-Waxman Act provides the first filer 180 days of exclusivity as the only generic drug permitted on the market, simply enabling a successful generic company challenger to recoup its significant litigation costs. It is this reward that encourages the risk of challenging a patent. If this exclusivity is no longer granted, the result will be the opposite of what this bill intends. Fewer drug patients will be challenged, and consumers will have to wait much longer until patents expire or litigation comes to conclusion before cheaper generic drugs can be made available. So I look forward to the testimony of our witnesses today, and thank you again, Mr. Chairman, for having this hearing.
The chair thanks the gentleman. The chair now recognizes the chairman of the full committee, the gentleman from California, Mr. Waxman, for 5 minutes for the purposes of opening statements.
Thank you very much, Mr. Chairman. I want to thank you for holding this important hearing. This year is the 25th anniversary of the Drug Price Competition and Patent Term Restoration Act, commonly known as Hatch-Waxman or Waxman-Hatch, and that law established our generic drug approval system. Generic drugs play a critical role in promoting public health. Where they're available, they promote competition, which in turn lowers prices. Lowering drug prices reduces overall health care bills. More importantly, though, lower drug prices mean access to important medications for many patients who might not otherwise be able to afford them. Today in the U.S., a remarkable 67% of prescriptions are filled with generic medicines, saving consumers and the federal and state governments tens of billions of dollars annually. Unfortunately, in recent years, we have seen that the vibrant competition we envisioned has not flourished as well as we had hoped. The Federal Trade Commission has highlighted a significant cause of this problem. Generic and brand name drug companies have increasingly been entering into patent settlement agreements that have an anti-competitive effect. These settlement arrangements frequently involve agreements in which the generic drug makers stay out of the market in exchange for some form of compensation from the brand name drug makers. These settlements are beneficial to both the brand name company and the generic challenger. The brand gets additional time to sell its drug at monopoly prices. The generic gets payments without any need to make or market the drug. Both the brand and generic firms profit, but they do so at the expense of the consumers who must continue to pay monopoly prices. This is the last thing Congress intended when we enacted Waxman-Hatch. The law was intended to give consumers access to generics at the earliest possible opportunity, not to line the pockets of generic and brand name drug companies. Some courts have erroneously concluded that these agreements were condoned by Hatch-Waxman. These courts are sorely mistaken. The use of our law to prevent generic competition is contrary to intent of that law. Now Congress must act to prevent the continued erosion of these principles. The Protecting Consumer Access to Generic Drugs Act of 2009, the bill under discussion today, is a sensible solution that will help put an end to the practice of paying generic drug companies to stay out of the market. I recognize we need to proceed with care. Some patent settlement agreements can provide benefits across the board. Settlements can allow the parties involved to avoid expensive, protracted litigation. Consumers can sometimes gain access to generic drugs that might otherwise have been deferred by litigation. This legislation recognizes that reality and permits settlements in which nothing more than the date of entry is negotiated. And if FTC decides that other exceptions need to be made to enhance competition and benefit consumers, then FTC can implement those changes through rulemaking. In effect, it's designed to rid us of the bad settlements and leave us with the good ones. And I look forward to the testimony of the witnesses today and working with all the members of the committee to get this bill enacted into law. Thank you, Mr. Chairman.
The chair thanks the chairman of the full committee. Now the chair recognizes the gentleman from Kentucky for Mr. Whitfield for the purposes of opening statement for the length of 2 minutes.
Mr. Chairman, thank you very much. We look forward to this hearing on H.R. 1706, Protecting Consumer Access to Generic Drugs Act. I think this legislation has the very best intents, and obviously we want to protect all sides in this debate. We want to be sure that innovative drug companies continue to spend money in research and development to come through with drugs that help curtail disease. We also want the consumer to be able to get generic drugs as soon as possible at a less cost to improve health care. And one of the issues that I'm going to be interested in today is that it was my understanding that in all of the legal actions filed by the FTC about these exclusion agreements that they had lost all of the lawsuits. But then in reading the memorandum, I see that in the Sixth Circuit Court of Appeals held that such agreements are per se violations of federal antitrust law. But in the Second and the 11th Circuit Court of Appeals, they've ruled that agreements do not violate antitrust laws and merely reflect the give and take of legal settlements. So I hope that as we proceed with our witnesses today that we can certainly get some clarification on that issue as well as others. And I'll yield back balance my time.
The chair thanks the gentleman. The chair now recognizes the gentleman from Maryland, Mr. Sarbanes, for 2 minutes for the purposes of opening statements.
Thank you, Mr. Chairman. I'm looking forward to the testimony today and anxious to see this proposal move forward, which I think is a very common sense solution to the distortion in the regime that's occurred as a result of the court conclusion that the FTC didn't have authority to regulate here and tries to remedy that. It's particularly important as we embark on looking at how to apply similar regimes to other arenas, which of course is a discussion that's going on now. We got to make sure we fix this one. Businesses and lawyers are clever in finding ways to get around impediments. That's what they've done here. And to use the vernacular, we just need to be cleverer and try to fix this, and that's what this legislation intends to do. So I look forward to the discussion today, and I yield back my time. Thanks.
The chair thanks the gentleman from Maryland. Now it is my pleasure to allow Mr. Pitts from from Pennsylvania, to allocate 2 minutes for him for the purposes of opening statement.
Thank you, Mr. Chairman. I'd like to thank you for convening a hearing on this bill. I think we all agree that our goal should be to make generic drugs available to the consumers who need them. I'm somewhat concerned that the legislation will have a chilling effect on patent challenges by generic drug companies, resulting in longer waiting periods for generic drugs for consumers who depend on them. This bill would place a total ban on all patent settlements in which the company that holds the patent on the brand name drug gives anything of value to the generic company challenging the patent except for an early entry date into the market. What will the results be? With no incentive to settle, cases will be litigated to the very end as brand drug companies fight to hold on to their authorized monopoly on a drug. The only way they have to recoup the millions of dollars they've put into developing and testing new drugs. With millions of dollars of legal fees on the line, generic companies will only challenge a patent if they are virtually assured of a successful outcome. This goes completely against the incentives for generics to challenge patents that are built into Hatch-Waxman. Finally, Since 2003, Congress has required that litigants notify federal antitrust authorities of their pharmaceutical patent settlements. DOJ and FTC are already notified of all patent settlements, and they can sue if they believe the outcome of a case is anti-competitive. FTC has filed suit in a number of cases, and in the vast majority, the courts have found these settlements acceptable and refused to strike them down. So, Mr. Chairman, the system is working. These settlements should be reviewed on a case-by-case basis, and to ban these settlements will only keep generics off the market for a longer period of time, hardly a pro-consumer outcome. I'd like to thank all of our witnesses for coming to testify today, and I yield back the balance of my time.
The chair thanks the gentleman. The chair now is deeply honored to recognize the chairman emeritus of the full committee, my friend from Michigan, Mr. Dingell, for 5 minutes for the purposes of an opening statement.
Mr. Chairman, thank you. And I want to commend you for your leadership and for holding this hearing. An issue before the committee today is a very fundamental question of fairness. Should pharmaceutical companies be able to continue to enjoy the right to collude via legal settlements in order to stifle consumer access to generic drugs? As the cost of health care continues to increase, mainly due to the cost of drugs, we must dispose of this question with a view towards providing consumers with a greater choice and lower prices, while at the same time preserving for the industry the inviolability of intellectual property rights for manufacturers of pharmaceuticals. At the root of this debate lie the Hatch-Waxman amendments to the Federal Food, Drug, and Cosmetic Act, whose intent it is to promote the aggressive entry of generic drugs into the marketplace to benefit consumers. Curiously, this has not occurred. This intent has been undermined of late by the growing practices of the pharmaceutical industry in settling patient disputes via the so-called practice of, quote, exclusion payments, close quote, in which a patent holder pays a generic challenger in exchange for delay in the generic drug's entry into the market. Who gets screwed here? The consumer. In my view, should a generic challenger prove its product does not infringe upon the patent held by a brand name pharmaceutical manufacturer, secretive agreements of a legal character between private parties should not prevent the generic drug's introduction into commerce. Clearly, this goes well against the intention of the committee and the Congress when we passed Hatch-Waxman. This in mind, the exclusion payments strike me as a counter to the interests of consumers and, more pointedly, an unfair method of competition, which would otherwise be prohibited under Section 5 of the Trade Commission Act. At this juncture, I would like to note that prohibiting exclusion payments may have a beneficial effect for state budgets and indeed for the federal government, because the budget of Medicare, Medicaid, and S-chip rolls are going to be stressed by both the depression that we now undergo and the awful situation that we confront of the increased need of people from formerly from groups that were formerly benefited by health coverage which they have lost. So we have a very serious problem of widespread economic displacement that is increasing these costs. By acting to proscribe uncompetitive practices like exclusion payments, we could reduce the strain on the states of providing their citizens with health care, something which I believe is a fundamental right of all Americans. I look forward to working with you, Mr. Chairman, to seeing this legislation through and to make it become law, and I urge my colleagues to be of assistance in this great undertaking. Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you, Chair. Thanks, the Chairman Emeritus. And now it is my pleasure to recognize the gentleman from Nebraska. I'm sorry, recognize my friend, I didn't see him not in there, my friend from Texas, the ranking member of the full committee, Mr. Barton, for 5 minutes for the opening statement.
Thank you, Mr. Chairman, and I look forward to the day we have a hearing on your bill and my bill to reform the BCS football championship series.
Will the gentleman yield for a moment?
I'd be happy to yield.
I talked about your bill, our bill this morning. I want you to know it's moving fast.
Very good. Well, the Senate's starting to, the Senate's beginning to steal our thunder, Mr. Chairman, so we don't.
can't let that happen.
We don't want to let that happen.
All right. They wouldn't know what to do with it.
Well, I do want to thank you, Mr. Chairman, for this hearing on generic drugs, which is part of this committee and this subcommittee's jurisdiction. Access to lower-cost drugs has not only helped Americans beat diseases, it's been a boon for health care in a world that depends on the drugs that we, the United States, manufacture. We need to recognize that it won't be all good news if we don't weigh the pros and cons of generics competing with brand names. Sick people depend on affordable drugs, but they also depend on innovation and research to create the drugs that they need. Without adequate reward, innovation fades, research declines, and life-saving medicine doesn't happen. The framers got it right in Article 1, Section 8 of the Constitution, and I quote, "Promote the progress of science by securing for limited times the exclusive right to discoveries." We should heed Section 8. It has worked well for over 200 years. American innovation is a cornerstone of intellectual property rights, and we need to ensure that our domestic industry continues to get the benefits of these property rights, especially in dealing with our trading partners overseas. Pharmaceutical companies should have the opportunity to pursue constitutionally protected inventions. We should not diminish the incentive to undertake the substantial risk involved. As everybody here knows, the risk associated with new drug approvals are significant. First comes the R&D component, followed by a lengthy FDA approval process, both of which require large amounts of money, which may not be recouped if the R&D falters or the FDA approval doesn't happen. At no point does anybody guarantee any drug innovator that the competition won't invent a similar drug first and get to the market first. I believe that when a new drug successfully makes it to market, we need to provide the innovator with intellectual property protection. It's important to get the balance right. In that spirit, Congress has always recognized the necessity of providing these protections. We've also recognized, obviously, the benefits of generic drug competition in the marketplace, which lowers cost and increases access. Congress made the wise decision 20 years ago when we passed Hatch-Waxman. I started to say Waxman-Hatch. I've always supported this concept of providing a balanced incentive for both sides of the industry because it works. Inevitably, however, patent disputes arise between generic firms and brand manufacturers. Litigation can and often does take years to reach a final verdict. However, both sides decide sometimes to settle a case when the outcome is uncertain and the parties have a negotiated settlement based on the possible benefits and the probabilities of winning the case outright. To be very clear, consumers should have the best drugs available at the cheapest possible price, but I think the best way to achieve that is to provide innovators with a strong intellectual property protection while providing a clear path for generics to enter the market. I have a serious concern about imposing a ban on the exchange of anything of value in a private patent litigation settlement. Limiting the options of private litigants to settle out of court should be avoided if at all possible. The right to defend or challenge patents should be preserved. Unfortunately, Mr. Chairman, I think the bill that you've introduced, H.R. 1706, would remove incentives parties have to settle, could force many more cases into lengthy litigation where years may elapse before a decision is reached. Forcing drug companies down this path probably would erode any benefit to the consumer. Since the FTC seems to me to have adequate authority to challenge these improper settlements in court, I'm anxious to hear from the witnesses as to why the judicial system is not the appropriate venue to resolve these issues. Finally, Mr. Chairman, as I said almost 2 years ago at our last hearing on this issue, I'm very interested in the economics of the industry and whether changing the structure of incentives and rewards, including some of the changes contemplated by your bill, will ultimately benefit consumers in the long run. I want to hear from the witnesses their views on this issue. and also whether they feel that there are antitrust concerns with these settlements, given the fact that the courts and the federal antitrust authorities don't seem to agree on the issue. But in any event, Mr. Chairman, this is an important hearing. I'm very pleased that you're holding it, and I look forward to hearing from the witnesses and also the questions from our distinguished members of the subcommittee. With that, I yield back.
The chair thanks the ranking member, and now it's my pleasure to recognize the gentleman from Michigan, Mr. Stupak, for 2 minutes for the purposes of an opening statement.
Mr. Chairman, I'm supportive of the bill, and I'll waive my 2 minutes and ask that be added on for questioning later.
The chair thanks the gentleman. Now the chair recognizes my friend from Ohio, Mr. Space, for 2 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman, for holding this important hearing on an issue that, at its core, is designed to provide inexpensive and effective medications or prescriptive medications to the people that we serve. I think in addressing this issue, like so many other issues that affect the pharmaceutical world, we have to walk a delicate line between fostering innovation and providing inexpensive access to constituents. Particularly the latter issue becomes important in light of the fact that so many people are hurting financially right now and actually making conscious decisions between purchasing prescription medication and buying food. I hope that we will consider these issues of intellectual property and patent settlements in a very deliberate process and be very careful and mindful to maintain that balance between fostering innovation while protecting consumers. And I'm hopeful that today's testimony will shed some important light on this topic. I yield back.
The chair thanks the gentleman. Now, for the second time now, the chair recognizes the gentleman from Nebraska, Mr. Terry, for 2 minutes for the purposes of an opening statement.
Well, I appreciate you asking me twice.
We're trying to get to you. Oh, boy. All right. Chair thanks the gentleman. Now it is my pleasure to recognize the gentleman from Louisiana, Mr. Scalise, for 2 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman. I'll waive as well and hold that time for questioning.
Well, we thank you. Now it's my pleasure to recognize the gentleman from Georgia, Mr. Gingrey, Dr. Gingrey, for 2 minutes for the purposes of an opening statement.
Mr. Chairman, the third time's a charm. I want to thank you for calling this hearing today on H.R. 1706, the Protecting Consumer Access to Generic Drugs Act of 2009. I believe that it goes without saying how valuable generic drugs have been for consumers in the prescription drug market. And this hearing will pick up where the subcommittee left this issue back in 2007 when I was not a member. As a physician for nearly 30 years and a member of this health subcommittee, I know that access to generic drugs provides proven medical remedies and improvements to the quality of life, and often at a much lower cost. As this subcommittee examines such an important issue for consumers across the country, we must act in a way that preserves and bolsters access to generic drugs. However, Mr. Chairman, despite the intent of H.R. 1706 to expedite the process by which generic drugs get to the consumer, I am concerned that this legislation may indeed have unintended consequences, causing consumers to wait even longer to get access to generic versions of brand-name drugs. At the very heart of this legislation is the legitimacy of an out-of-court settlement between a drug company holding a patent on a drug and one seeking to create the generic version. Mr. Chairman, patent law in this area is very unique. When companies are able to settle their disputes out of court, consumers are the ultimate winners. Unfortunately, H.R. 1706 would prohibit the practice, thus reducing the incentive for a generic company to take on the financial burden of challenging patents and potentially delaying some generics from actually coming to the market. Mr. Chairman, for the sake of all healthcare consumers, I urge we use the utmost caution and care as we move forward on this legislation. I certainly look forward to hearing the thoughts of our panel this morning on such an important issue. And I yield back the remaining 30 seconds.
The chair thanks the gentleman. Now, the chair recognizes my friend from Georgia, Mr. Barrow, for 2 minutes for the purposes of an opening statement.
I thank the chair. In the interest of time, I'll waive an opening.
Thank you very much. Now, the chair recognizes my friend from Illinois, Ms. Schakowsky, the vice chair of the subcommittee, for 2 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman. I'm an original co-sponsor of H.R. 1706, the Protecting Consumer Access to Generic Drugs Act of 2009, because I believe that the availability of generic drugs is a critical component to lowering health care costs for the consumer, for businesses, for the taxpayer. The legislation would prohibit patent settlements in which a brand-name drug maker pays off a generic drug maker to prevent the generic medicine from entering the market. These payments are known as reverse or exclusion payments. And it strikes me as incredibly disingenuous that those who would tout the importance of free markets and competition would also take explicit action to prevent fair competition in the case of necessary and sometimes life-saving prescription medications. Settlements that include exclusion payments may be good for the brand name manufacturer that gets to keep its monopoly, and it may be a good thing for the generic company that gets paid not to produce a drug, but such settlements are a bad deal for consumers. My state of Illinois has joined others in successfully taking on antitrust actions by brand-name drug companies. In 2003, Illinois was part of a multi-state settlement of an action against Aventis for entering into an exclusion payment settlement with a generic challenger which delayed competition with its heart drug, Cardizem. However, the Cardizem case predated recent circuit court decisions that have made it more difficult for antitrust enforcers to challenge reverse payments. The case, which garnered millions of dollars for Illinois consumers, might not have been successful in the current environment. According to a 2004 FDA analysis, the average patient taking several medications could save 14 to 16% on drug costs if they can replace some of their prescriptions with generics. If they were taking medications that could be completely replaced with generics, their prescription drug costs could be reduced by 52%. I think that ensuring lower cost generics are on the market is a key component of reining in health care spending, and I believe that setting the bar any lower would be irresponsible on the part of this Congress. Thank you, Mr. Chairman.
The chair thanks the gentlelady. Now the chair want to exercise a moment of personal privilege this morning by recognizing the chairman of the Federal Trade Commission, who's come here to be with us this morning. I'm not sure, Mr. Chairman, how long you'll be able to stay, but you're always welcome here. We want you to know that anytime you want to drop in, just drop in, all right? Mr. John Leibowitz is recognized. We thank you so much for your presence. And now we will like to welcome our expert and esteemed panel that have come with us. I want you to know that you're the finest panel that ever assembled before us this morning, all right? And we recognize you so much, and we thank you so much for being here with us. I want to recognize from my left to right, beginning with the Honorable J. Thomas Rush, who's a commissioner of the Federal Trade Commission. We want to recognize you, Commissioner Rush. I think that's how you pronounce your last name. Thank you so much. Next to him is Mr. Scott Hemphill, who's an associate professor of law at Columbia University. Welcome, Mr. Hemphill. Next to Mr. Hemphill will be Ms. Joanne Handy. She's a board member of an organization I just recently joined, the AARP. Welcome, Ms. Handy. Next to her is Ms. Diane Beery. She's a general counsel for PhRMA. Welcome, Ms. Beery. Next to Ms. Beery is Dr. Barry Sherman, who is the Chief Executive Officer for Apotex Incorporated. Dr. Sherman, you've been here before at this committee, and we welcome you once again. And next to Dr. Sherman is Mr. Ted Whitehouse of the firm Wilkie, Farr, and Gallagher, who's been before this committee before, and he's here on behalf of Teva Pharmaceuticals. We certainly want to, again, welcome each and every one of you, and thank you for taking out moments from your important day to be here with us. And now we will recognize Commissioner Rush for 5 minutes for the purposes of an opening statement. Turn the mic on, please. Put it closer to you.
Okay. I appreciate the chance to appear before you today. The written statement that we submitted represents the views of the Commission as a whole. My oral testimony is my own, and it doesn't necessarily reflect the views of any other commissioner. There are several compelling reasons why it's imperative that Congress enact legislation in this area. Reverse payment agreements strike at the heart of the special statutory framework Congress created in the Hatch-Waxman Act. That framework was designed to balance two policy goals that are critically important to the pharmaceutical industry. Hatch-Waxman gave branded companies a longer patent life. The trade-off was that generic companies were given a strong incentive to challenge questionable brand patents and start competing with the branded companies if they win. And that trade-off was 180 days of generic exclusivity. In that way, generic companies were supposed to protect consumers from unwarranted patent monopoly pricing by branded companies. But reverse payment settlements frustrate the purpose of Hatch-Waxman in two ways. First, the settlements incentivize the generic to abandon the patent challenge, leaving a suspect patent intact for the entire extended patent period. Second, they can incentivize the generic to challenge patents that shouldn't be challenged in hopes of getting paid off for settlement. In other words, these anti-competitive settlements have ended up vitiating the incentives for generics to protect consumers, and instead can result in generics feathering their own nests. By virtue of the reverse payment settlement agreement, the brand stops the generics challenge, and so it doesn't lose its patent monopoly, even if its patent is invalid or not infringed. The generic, meanwhile, gets a share of the brand's monopoly profit in the form of the reverse payment. But the consumer, including the federal government, as has been pointed out, ends up being a huge loser, since consumers continue to pay monopoly profits until the generic starts to compete. This is demonstrated by the pie chart on page 12 of the Commission's written remarks. And a good example is our Cephalon case, where the CEO of the brand boasted that his deals generated an additional $4 billion in sales. Most of the profits from those sales will come from consumers' pockets. Now imagine if there are 10, 15, or even more of these settlements each year. Beyond that, on their face, reverse payment agreements are market division agreements between potential competitors. That's why the Sixth Circuit in the Cardism case held that they were per se illegal. And that holding is consistent with the 1990 Supreme Court Palmer decision, which held that market division agreements between potential competitors are per se illegal. So reverse payment agreements not only violate the purpose of Hatch-Waxman, but also seemingly violate the Palmer holding. So why am I here, supporting congressional legislation? Well, recent circuit court decisions have ignored Palmer and Cardism, substituting their own judicial policy judgments that market division agreements should be permissible to settle patent litigation. For example, the 11th Circuit's Shearing decision, in which the Circuit Court declined to follow Palmer or Cardizem, emphasized that its decision was based on, quote, policy, end quote. But Congress is the body with the responsibility to set patent policy. In short, the courts have disturbed the balance that Congress struck in Hatch-Waxman by permitting reverse payment settlement agreements, and Congress should correct that imbalance. Congress shouldn't wait for the Supreme Court to review these erroneous judicial decisions either. There's no reason to think that the court will set things right anytime soon. It's declined to review both Shearing and tamoxifen, which followed Shearing, that's the Second Circuit decision, and the petition currently before the court in the Cipro case, the most recent of these decisions. In that petition, the petitioner actually suggests that the Supreme Court defer ruling on the petition until the parties file a petition in a parallel action. More important, however, Cipro represents the extreme case. It holds that reverse payment settlements are, in effect, per se legal, not illegal, but per se legal. Even if the court concludes that Cipro is wrong and that reverse payment agreements are not per se legal, that still leaves open the question whether, as Shearing and tamoxifen held, the strength of the patent is a threshold issue that has to be litigated before the public or private plaintiff can litigate the antitrust merits. I've said publicly, Mr. Chairman, that litigating the strength of the patent may be one way to avoid Shearing and tamoxifen, but I'll be the first to admit that that may be costly and duplicative. Hatch-Waxman contemplated that the generic would litigate the strength of the
Mr.
patent.
Commissioner, would you please bring your comments to a close? You're a minute and 47 seconds over your time.
Okay. Can I just conclude by
Please,
saying,
please.
Mr. Chairman, that at the Commission at least, this is not a partisan issue. 11 members of the Commission over the years that this has been at issue, all the Republicans, all of the Democrats have joined in these cases, and all four of us, 2 Republicans and 2 Democrats who are currently on the Commission, strongly support the legislation that is before the committee. Thank you.
Thank you very much. Now the chair recognizes the gentleman, Mr. Scott Hemphill, for 5 minutes or thereabouts for the purposes of an opening statement.
Thank you. Chairman Rush, Congressman Stearns, and members of the subcommittee, I'm Scott Hemphill, an associate professor at Columbia Law School. My scholarship and teaching focus on the balance between innovation and competition established by antitrust law, intellectual property, and regulation. I thank you for the opportunity to testify today about anti-competitive pay-for-delay agreements between brand-name drug makers and their generic rivals. These remarks draw upon my ongoing academic research into the economic effects of these settlements and their appropriate legal treatment. Most recently, an article forthcoming in the Columbia Law Review. I hope these articles might be included in the hearing record.
So ordered.
I've advised the Federal Trade Commission on the antitrust issues raised by pay-for-delay settlements, but the views I express today are mine alone. For 25 years, the Hatch-Waxman Act has provided a way for generic drug makers to introduce a competing version of a patented brand-name drug, even before the relevant patent or patents expire, by arguing that the patent is invalid or not infringed. The generic firm has a large incentive to do this. 180 days of exclusive sales, free from generic competition when it later enters the market. Usually the brand name firm files a patent infringement suit in response. Often the generic firm wins the suit, and when it does, drug prices fall. But sometimes the brand name firm, instead of taking that chance, decides to settle the suit. The parties dismiss the suit and agree on a particular date when the generic firm can enter the market. That date is the result of a hard bargain between the two companies. The brand name firm pushes for as late a date as possible, arguing that it's likely to win the case at trial if put to the test. The more persuasive that argument is, the later the entry date. Now, such a settlement which rests solely upon the inherent strength of the patent is properly permitted, but now think what happens when a brand name firm instead makes a payment to the generic firm, rather than relying solely on its prospects at trial. In that case, the payment secures a later date than is warranted by the likely validity of the patent alone. That payment to a rival made to secure additional delay in generic entry ought to be prohibited. This pay-for-delay settlement problem is growing. To get a better sense of the problem, I collected a data set using public information of 143 brand generic settlements between 1984 and August 2008. Of these, 60 settlements raise pay-for-delay issues. Settlements as to just 10 drugs whose form is particularly troubling and which currently block generic entry account for U.S. sales of about $17 billion each year. The problem is not just growing worse, it's also getting harder. In the early days of pay-for-delay settlements, the brand name paid cash, a couple $100 million in the case of the antibiotic Cipro. These deals are, relatively speaking, easy to understand. But today, firms also pay by making contemporaneous side deals that help to disguise the payment. And they can even use the 180-day period I mentioned a moment ago as a source of payment. Let me explain. A generic firm gets the 180 days if it fights the patent and wins. It loses the 180 days if it fights the patent and loses. But what if it settles? In that case, it keeps the 180 days. Now, this is important because it means that a brand name firm can approach the generic and say, let me keep my patent, and in exchange, I'll let you have the 180 days, just much later. For a blockbuster drug such as Lipitor, such forbearance is worth hundreds of millions of dollars to a generic firm. The current approach to pay-for-delay settlement is just not working. H.R. 1706 is an important step forward in identifying and deterring pay-for-delay settlement. Section 2A of the bill prohibits a settling brand name firm from providing a generic firm with, quote, anything of value beyond a negotiated entry date, and with a few specified exceptions. It's important that the subcommittee recognize that anything of value, properly understood, includes all forms of compensation that induce delay, including effective guarantees of exclusivity. The subcommittee might wish to make this point explicit in the bill. To conclude, the pay-for-delay problem is getting worse as new deals are made and as deal structures become more and more complicated. Congress can help by prohibiting these anti-competitive arrangements. Thanks are due to the subcommittee for taking a leadership role on this important issue. I look forward to hearing your questions and concerns.
The chair thanks the gentleman. Now the chair recognizes Ms. Joanne Hardy for 5 minutes for the purposes of an opening statement.
A member of the AARP board, also a nurse and a healthcare provider. On behalf of our more than 40 million members, thank you for the chance to testify about H.R. 1706. AARP has endorsed this legislation, and we call on Congress to enact this legislation this year. Older Americans, as has been referred to several times by members of the subcommittee, use prescription drugs more than any other segment of the U.S. population. Unfortunately, the costs for brand name drug products continue to rise at rates that far exceed inflation, causing a strain on the budgets of both consumers and other healthcare payers, including the government. Spiraling drug costs are particularly hard for older adults who are disproportionately affected by chronic disease and more likely to need multiple medications. When faced with higher drug costs, they frequently skip doses, reduce doses, and let prescriptions go unfilled. The result is preventable and expensive hospitalizations and adverse health outcomes. This occurs far less often for those taking generic drugs, which have proven to be one of the safest and most effective ways for consumers to lower their prescription drug costs. AARP encourages its members to use generic drugs whenever possible. AARP strongly supports efforts that provide timely market entry of generic drugs. We are concerned, however, about the recent trends in reverse payments, which occurs when generic manufacturers receive anything of value in exchange for agreeing not to research, develop, manufacture, or sell its generic products. These reverse payments delay market entry of new generic drugs and thus increase the odds that older Americans will be forced to cut back or go without needed medicines because of the rising cost. AARP believes that H.R. 1706 is an appropriate remedy to end the problem of reverse payments. This legislation is needed because when brand and generic pharmaceutical companies engage in conduct that delays market entry of generic drugs, consumers and other healthcare payers pay higher prices. And as a result, older Americans are more likely to go without the drugs they need because of the higher cost. Stopping or delaying market entry of the first generic drug prevents all the other generic drugs from competing and ultimately extends the brand name manufacturer's market exclusivity. This creates a powerful incentive for companies to negotiate, to collude with the first-to-file generic manufacturer to delay market entry of the generic product. Legislation is necessary because, as you've heard, there have been recent court decisions that have held that reverse payment agreements do not violate the antitrust laws. These decisions have unquestionably led to an increase of such agreements and hampered the Federal Trade Commission's ability to prevent these abuses. In fact, the FTC has reported a marked increase in the number of questionable settlements. 50% of the 2006 settlement agreements between brand and generic manufacturers included some form of payment as well as an agreement to delay market entry. Ending these costly patient abuses is one essential component in our efforts to reduce skyrocketing brand name drug prices and provide affordable, comprehensive health care options to all Americans. Again, AARP strongly supports H.R. 1706. We are pleased to see the committee and members from both houses of Congress and both sides of the aisle moving forward on this issue. Thank you for inviting us to be here.
Thank you. Now the chair recognizes Ms. Diane Berry, who's the General Counsel for Pharma, for 5 minutes for the purposes of opening statement. Welcome.
Thank you. Chairman Rush, Congressman Stearns, and members of the subcommittee. Thank you for the invitation to participate in today's hearing on legislation that could have a significant impact on pharmaceutical companies' settlements of patent disputes. My name is Diane Beery, and I'm the Executive Vice President and General Counsel of Pharma. In 2008 alone, Pharma members, including both large and small biotech and pharmaceutical companies, invested more than $50 billion in discovering and developing new medicines. What's more, roughly 70% of this research was made right here in the United States, representing a significant number of American jobs and other contributions to the economy. In the past 10 years, over 300 new medicines have made it through the increasingly complex FDA review process and into the hands of physicians and patients. These new medicines are increasing life expectancy, decreasing disability, and providing hope to patients and their loved ones who are fighting life-threatening and debilitating diseases such as cancer, cardiovascular disease, diabetes, rheumatoid arthritis, and many others. America's biopharmaceutical companies are facing more challenges than ever in terms of bringing new medicines to market. It takes, on average, 10 to 15 years and more than $1 billion to bring one new medicine to patients. That is why research-based companies and their investors need to be confident that the law will respect and uphold the critical role of intellectual property, including patents, in providing the opportunity to recoup these substantial investments. Patent protection is the engine that allows America's research-based biopharmaceutical companies to take risks and strive to develop the next generation of life-saving and life-enhancing treatments. Of course, it is important to remember that pharmaceutical products effectively have a shorter period of patent life than other types of products. Pharmaceutical companies must obtain FDA approval before marketing their products, and much of the patent term is spent before the medicine actually comes to market. Recognizing these challenges, the Hatch-Waxman Act of 1984 attempted to balance the interests of both innovative and generic companies. The law made it easier for generics to come to market, but also restored to innovators some of the patent time lost during the clinical research and regulatory review process. But even after Hatch-Waxman, the useful patent life of a pharmaceutical product is limited. For example, one study showed that for medicines whose generic competitors entered the market between 2002 and 2005, the average time on the market before generic competition was only 11.2 years. In addition, you have to look at the tremendous increase in competition between brand medicines, but particularly between brand medicines and generics. Since passage of Hatch-Waxman, the generic industry share of the prescription drug market has jumped from less than 20% to over 71% today. This is, of course, due in part to the fact that Hatch-Waxman has spawned more patent challenges, as it was meant to do. Hatch-Waxman gives generic companies incentives to challenge patents as soon as 4 years after the brand medicine receives FDA approval, without requiring the generic to take the risk of actually marketing the product before the patent challenge is resolved. Given this construct, patent challenges have become commonplace. But patent litigation is still lengthy, expensive, and risky for all concerned. Generic companies do not have perfect information when they bring challenges, and brand companies cannot be sure their view of the strength of their patents will carry the day at trial. The rapid expansion in generic utilization has been fueled in part by the fact that innovators and generics have had the flexibility to resolve some of these patent suits in fair and appropriate ways without taking every case the whole way through trial and appeal. There is no doubt that H.R. 1706 would significantly reduce that flexibility. Courts and experts tell us that patent settlements between brand and generic companies, even those that include some payment from the brand to the generic, can benefit consumers. Yet H.R. 1706 would prohibit a wide variety of patent settlements just because the brand company transfers something of value to the generic. This kind of broad ban would chill all patent settlements and is likely to reduce innovation and also reduce the number of patent challenges filed. Broad limits on options for patent settlements would force both sides to spend valuable resources litigating rather than developing new medicines or bringing generic versions to market. Statistics from recent years show that innovators are likely to win over 50% of the cases litigated through appeal, which means that generic entry in those cases would not come until the patent expires. In contrast, a settlement might include provisions allowing a generic product to come to market well before the patent expires and could produce other collateral benefits, such as licenses for generics to market products unrelated to the patent dispute. Instead of a blanket rule banning certain types of patent settlements, enforcement agencies and courts should continue to evaluate settlements on a case-by-case basis to determine whether, on the whole, they benefit consumers. The Medicare Drug Improvement and Modernization Act of 2003 enhanced the FTC and Department of Justice's ability to make those determinations. This approach preserves the delicate balance between intellectual property protection that fosters innovation and competition principles that encourage access to generic medicines and a strong, healthy generic industry. I look forward to answering any questions you may have, and PhRMA looks forward to working with you on this legislation. Thank you again for your attention to these important policy issues.
The chair thanks Mrs. Berry, and it's now my honor to introduce and to allow Dr. Barry Sullivan 5 minutes for the purposes of opening. Sherman, 5 minutes for the purposes of opening statement. Dr. Sherman, you're recognized for 5 minutes.
Okay. Mr. Chairman, members of the subcommittee, thank you for the opportunity to testify again today. Apotex, Inc. is very eager to do its job of challenging weak patents and bringing to the market products as quickly as possible for the benefit of our customers, who are the pharmacy industry of America, and through them to American consumers. We are therefore eager to help elucidate the fundamental problem that is blocking generic entry, and that, in our view, is settlements by first filers that whereby they accept unduly late, very late entry dates, keep their exclusivity, and thereby block market entry to others such as us who would continue to fight and thereby gain much earlier market entry. And the cost to the American consumer is enormous, billions of dollars for individual products, and certainly many tens of billions of dollars in total. One example is the drug modafinil, whereby the Cephalon settled with 4 generic suppliers, challengers, some years ago, and thereby got delayed generic entry until the year 2012. The patent is very weak. We would be prepared to launch the product now if we could, and indeed in Canada, we've already succeeded in the patent challenge, and the product is on the market in Canada as a generic sold by Apotex. So the problem is quite enormous. There have been legislative initiatives, including this one, to address the problem by trying to prohibit reverse payments, settlements that include reverse payments. In our view, reverse payments per se are not the problem. They're simply a symptom of a problem. Why are brand companies prepared to make large payments? It's not because they are fair payments to the particular company with whom they are settling. It's because when they settle with the first filer, they know the first filer retains the exclusivity and blocks all others. So they are paying not because, not to get the one settlement, to get the entire block of the market until near patent expiry, and that is the fundamental problem. In our view, there are two flaws that need to be addressed and can easily be addressed. The first is that the first filer who settles and doesn't do what was intended by the Hatch-Waxman provision gets to keep that exclusivity to block all others. And the second problem is that these agreements almost always contain poison pill provisions whereby if a subsequent filer does succeed to get early entry, the settler simply accelerates entry and takes away the benefit to the subsequent filer who actually succeeded. One example that brings the point home is the case of Altace Ramipril. The first filer was Cobalt. They settled for very late entry, but in 2007, Lupin won, even though they were not the first filer, won in the Court of Appeal. What then happened? Cobalt used its poison pill provision to accelerate its entry, launched the product, and Lupin could not launch, even though they were the ones who invested and won. So all of the benefit went to Cobalt, who had settled. None of the benefit went to the successful litigant who was not the first filer. The message from that case is clear to all who would subsequently challenge a patent: don't do it, it isn't worth it, you can't succeed. So the effect is that the litigation by those who would actually fight to win is paralyzed. In our view, there are two simple amendments that are needed to fix this problem. The first amendment is to give a shared exclusivity to a subsequent filer who does fight and wins. And the second provision that is needed is to override the poison pill provisions, which would, in essence, provide that if a first filer settles for very late entry, FDA can then not give final approval to that first filer until that date, and that date can then not be accelerated by reason of a subsequent win by a subsequent filer. These two provisions would accomplish two very important things. Number one, it would give, when there is an anti-competitive settlement whereby a first filer has agreed to defer to a very late entry date, it would give an incentive to a subsequent filer to pick up the battle, challenge the patent, and win and get earlier entry. And the second effect would be that it would eliminate the anti-competitive settlements, because if these provisions were enacted, a brand company would no longer make a reverse payment to a first filer because it wouldn't have the effect of blocking all challengers. It would only block the one, and therefore there would be no reason to make the first that big payment. And secondly, it would tell the first filer that it shouldn't settle for too late a date, because if it does, it will be stuck with that date, and then will lose the opportunity to launch if a second filer, a subsequent filer, wins an earlier entry date. So in our view, the attacking or trying to eliminate reverse payments really will not solve the problem. This anti-competitive settlements will continue with the same anti-competitive effect, only without the reverse payments. And what is necessary to address the problem is to give shared exclusivity to a subsequent filer who does take up the battle and wins, and to eliminate the poison pill provisions whereby a first filer who agrees to late market entry can then accelerate that entry on the basis of an earlier win by someone who does invest in the challenge and wins. We very much urge the committee, the subcommittee, to consider our suggestions, because we've been at this for a very long time. We understand what the issues are. We're fighting the battles every day. We are most eager to do the job which the Hatch-Waxman provisions incentivized us to do, to fight, to win, to bring products to market early. We are blocked by these anti-competitive settlements, and these are the changes that we are convinced are needed to solve the problem. Thank you very much.
The chair thanks the gentleman. Now, the last witness, the chair recognizes for 5 minutes. Mr. Whitehouse, you're recognized now for 5 minutes for the purposes of opening statement.
Thank you. Chairman Rush and Congressman Stearns and members of the subcommittee, good morning. I am Ted Whitehouse. By now it's good afternoon. I'm a partner at Wilkie Farr & Gallagher and appearing today on behalf of Teva Pharmaceuticals, which, as you know, is a leading pharmaceutical company that participates both on the generic and the brand sides of the industry. Teva and I appreciate the opportunity to appear and be heard on these important issues. As I think you know, Teva has been an active participant in the last Congress and in the current Congress in the deliberations and on the matters at issue in this hearing. We hope it has been apparent to everyone that Teva is very concerned about this and similar legislative proposals, but also very willing to work constructively with Congress and the FTC in an effort to ensure that the concerns being raised here are addressed without doing harm to the vital concerns and incentives at the heart of Hatch-Waxman. Teva believes that the intricately crafted Hatch-Waxman process that Congress put in place 25 years ago has worked and is working very well. Teva's basic position is that no new legislation is needed. Teva is therefore opposed to H.R. 1706. Teva believes the ability to reach reasonable, timely, and pro-consumer settlements in Hatch-Waxman Paragraph 4 litigations is absolutely essential to Teva's effort to bring low-cost generic drugs to market as soon as possible. And that is Teva's fundamental business, to work to bring products to market as soon as possible. From the perspective of consumers, settlements that result in bringing products to market sooner and with more certainty than might otherwise be the case are a very good thing. Teva believes that the members and staff should give particular attention to a recent paper written by 3 prominent economists, including Dr. Laura DeAndrea Tyson, a professor of economics at Berkeley who served as chair of the Council of Economic Advisors and as director of the National Economic Council in the Clinton administration. She's joining the Obama administration to advise on tax policy, as we understand it. This paper, copies of which we believe have been distributed to all members and their staff, confirms, on the basis of economic analysis and theory, some of the conclusions that Teva reached from its practical experience. First, that settlements can be good for consumers. Second, that reasonable settlements are more likely to be achieved if parties have more than 1 or 2 issues over which to bargain. And third, the paper emphasizes the importance of case-by-case analysis of settlements rather than a blanket ban on particular terms. As Dr. Tyson's co-author said in a letter sent yesterday to the chair and ranking member, quote, "A broad ban on certain types of patent settlements, such as that considered in the proposed legislation, will likely make American consumers worse off." Teva does not contend that all Hatch-Waxman settlements are necessarily good for consumers, but it takes strong issue with the legislation that would have prevented Teva from engaging in any of the recent settlements that Teva reached that produced real benefits for consumers. For example, 10 settlements entered into by Teva between 1999 and 2007 took approximately 80 years off the lives of the patents in issue and will end up saving consumers more than $67 billion. Teva believes that more serious consideration should be given to legislative alternatives that were extensively discussed in the last Congress, such as mandatory expedited review by the courts or a more formal expedited FTC pre-effectiveness review process. If the subcommittee determines to proceed with the approach embodied in H.R. 1706, Teva strongly urges that the exceptions or carve-outs in the bill be broadened to make clear that at least the kinds of terms that Teva has successfully employed in the past to reach settlements that produced real benefits for consumers remain permissible. And those provisions include, among other things, early generic entry on other products, in addition to the one in suit, a full release for damages and a covenant not to sue on all patents on the generic products involved in the settlement, a limited exclusive license, and case-by-case authority for the FTC. Now, most of H.R. 1706 is directed to patent settlements. However, Section 4 addresses a different set of issues, not tied or limited to patent settlements. Essentially, Section 4 would broaden the circumstances under which the first generic company to challenge a brand company's patents could lose or forfeit the 180 days of marketing exclusivity provided to first filers under Hatch-Waxman. As you've heard today, there are people in the industry who don't like the 180-day exclusivity provisions, but it is important to be very clear that those provisions have been in Hatch-Waxman from the start and are absolutely central to the incentive structure that has brought this country the vibrantly competitive and publicly beneficial generic drug industry from which consumers, third-party payers, and the federal and state governments benefit every day. I respectfully invite your attention to my written statement for a full explanation of Teva's concerns relating to these complex provisions in Section 4. But very briefly, by way of example, as written, subsection CC would result in forfeitures of exclusivity before anyone has been cleared to enter the market. Proposed subsection DD, we believe, is confusingly unclear and potentially very overbroad. On all of these issues, Teva hopes to continue an active and constructive dialogue with members of Congress and their staffs, and with FTC commissioners and the FTC staff, all with a view to trying to address any legitimate concerns while carefully preserving all that is good and necessary about the existing and highly successful Hatch-Waxman process. Thank you very much. I'd be pleased to answer any questions that you may have.
The Chair, thanks, Mr. Whitehouse. And now the Chair will begin the round of questioning by recognizing himself for 5 minutes for the purposes of questioning the witnesses. And I just want to ask the witnesses if we need to go into a second round of questions. The Chair is willing to do that if the witnesses can make themselves available for an additional round of questioning from the members of the subcommittee. The Chair recognizes himself for 5 minutes. Exclusion payment settlements are unique to the pharmaceutical industry. In all other industries, as I stated in my opening statement, patent disputes are settled in 2 ways. One, the accused infringer pays a royalty to the patent holder, or 2, the 2 parties agree to an early entry date. It is my belief, and has been stated earlier, that only in the pharmaceutical industry do we see the very unusual behavior of a patent holder, which the brand name drug company, suing the accused infringer, the generic company, and then paying the accused infringer to stay off the market. Only in the pharmaceutical industry. I want to ask Commissioner Rush, do these types of settlements happen in any other sector? And while you're answering that, think about this question. Why are these settlements unique to the drug industry, and what keeps them from occurring in other industries or commercial sectors? And how does the framework of Hatch-Waxman impede or enhances this kind of activity? Those are the questions that I have for you.
Chairman, let me take them up one by one. First of all, yes, I do believe that these kinds of settlements, that is to say, the kinds of settlements with which this legislation is concerned, are unique to the pharmaceutical industry. I think I take issue with characterizing them as payment settlements. They are not that. They are reverse payment settlements. They are settlements in which the holder of the patent actually pays the person who is alleging infringement some money or other thing of value. We do not, frankly, see that kind of settlement in any other industry. So that's the answer to the first question. Second, why don't we see it in any other industry? It is not because we consider either the branded or the generics to be nefarious. It is simply a matter of economics. Now, what am I talking about in terms of economics? First, state substitution laws, as well as various kinds of formularies, very much encourage switching to a lower cost drug from a branded drug that is under patent. Second, because of that encouragement, generic drugs are inclined and incentivized to switch their drugs as quickly as possible. And to do that, they are willing to actually take a haircut on their prices, well below that the brand charges, because the brand is able to charge monopoly prices. Third, that threatens, however, the brand tremendously because the brand's drug is still under patent, and it is able to avail itself of monopoly pricing, brand monopoly pricing, as well as brand monopoly profits. Fourth, because it is so threatened, the brand is willing and incentivized to go ahead and share some of those profits with the generic. And that is what happens when it offers a reverse payment. It is, in fact, sharing some of those profits with the generic. So finally, the reverse payment settlement is a win-win proposition for both the brand and the generic. It helps the brand, on the one hand, maintain its patent monopoly. And secondly, however, what it does is to incentivize the generic to abandon its challenge to the patent monopoly and therefore to eschew the kind of pro-consumer activity that the Hatch-Waxman Act was originally designed to encourage. There is nothing wrong with the original Hatch-Waxman Act. To the contrary, its incentives were perfectly aligned. It gave the brand something, it gave the generic something for challenging the brands. The problem is not with the Act. The problem is with the court decisions which have ignored the teaching of the Supreme Court as well as what the framers of the Act had in mind in enacting the Act to begin with.
The chairman's time is ended, and now the chair recognizes my friend from Florida, Mr. Stearns, for 5 minutes for the purposes.
Thank you, Mr. Chairman. I ask unanimous consent that the letter that was sent to you and Mr. Radonovich, the academic study that draws a reference that Mr. Whitehouse mentioned, draws out the complexity of determining whether reverse payment settlements are anti-consumer and demonstrates that these settlements are actually pro-consumer, in most cases, being made part of the record.
Hearing no objections, so ordered.
This is an interesting hearing, Mr. Chairman. You have the pharmaceutical industry, and as I understand it, the generic drug industry is aligned together. It's the most unlikely alliance here. Mr. Whitehead and others I represent, as I understand it from my staff, Dr. Sherman, you're alone here, that most of the generics, isn't that true, Dr. Sherman, that most of the generics are not supporting this bill? Is that true, Mr. Whitehead? Most of the generic companies are not supporting this bill?
That is correct.
Okay, and then the pharmaceuticals, obviously, Ms. Berry, do not support it. So I say to Mr. Rush, you have here the pharmaceuticals against the bill, the generics against the bill. In this case, you pointed out pretty in detail how the courts have ruled that the Hatch-Waxman bill is working and that these reverse payments that you don't like my term, the settlement payment, that they actually are acceptable legal remedy and they're not anti-competitive. Isn't that true, Mr. Rush?
Some of the courts have done that.
No, but in general, didn't all the courts show that these agreements are not anti-competitive?
No, that is not correct. The Sixth Circuit in the Cardism case held that they were, in fact, per se illegal. The 11th Circuit and the Second Circuit, however, have held otherwise as a matter of policy. And as I said before, I think it's Congress's authority to make policy.
Did you say the Supreme Court wouldn't even rule on this because it was decided by the lower courts?
No, the Supreme Court did not rule on it because, as you know, the Supreme Court doesn't review all circuit court decisions.
Well, wouldn't you say the majority of courts have ruled that this is not anti-competitive?
2-1, you're correct.
2-1, okay. So we established 2-1 the courts. So what this bill is trying to do is circumvent the courts, and where the courts have heard legal arguments on both sides, and a 2-1 majority have said that this reverse payment that you use, which I say is a settlement payment, is not anti-competitive. Is that a true statement?
No, it is not correct. First of all, because the Supreme Court has held in other contexts, that is to say when they're not part of a settlement, that exactly.
But not in this context.
No, the Supreme Court has not addressed this.
That's what I'm saying. Okay. You know, I think when you look at the statistics, that before the Hatch-Waxman, only 19% of the generic industry share of the prescription drug benefit was only 19%. After the Hatch-Waxman, it went up to 70%. So that would show that it's working. I hear no evidence that if we pass this bill that you're going to go from 70% to 80 to 90%. In fact, you might go lower. And Mr. Whitehead, if this bill passed, the statistics I just gave you before the Hatch-Waxman went to 70%, do you think the statistics will go lower if this bill's passed?
We believe it's documented in this economic study that there's a very real risk that there will be disincentive to the generic companies.
So why would we want to do harm then when with something that the court says is not anti-competitive? We've got both people involved have indicated they don't want it to happen, and we've got a study that say the overwhelming statistic that is going up to 70% is working, and we have a study that says, in fact, if you pass this bill, the consumers will have less choice, and so it's a little interesting to me. And I have Mr. Rush, here's a question for you.
Thank you.
When you have statistics where it says that the study claims that in all patent litigation initiated between 1992 and 2000, the generics prevailed in 73% of the challenged drug products. But I don't think that's telling the whole story. How many of these wins resulted in actual generic products coming on the market?
Well, let's assume that it's 45%. As you
No, let's just take 73% as the statistics that's used. Of that 73%, how many of those resulted in actual products being put on?
I can't.
You know why? I can tell you it's probably low, because if a product consists of color, shape, compound, and dissolution, and they might win 3 of the cases. They say, okay, we won on color, shape, and dissipation, let's say, but the actual content of that, the compound itself, they lose on, they can't do anything.
Well, let's assume it's 45%, as you suggested earlier.
Okay.
Let's assume it's 45%. That means that in 45% of the cases, these reverse payments are actually operating to hurt consumers. Under those circumstances, even if it's
No,
one
but ultimately,
case,
with the reverse payment, settlement payment, my terms, with that means the generic drug finally comes on. Otherwise, it would be, I think you mentioned that 80 years, or somebody in the panel said it would take 80 years of litigation. So you suddenly have this litigation abruptly stop. You have in 6 months the possibility of generic coming on the market, and this whole litigation process ends.
well, there's nothing in the bill that would chill settlements at all. There were lots of settlements that were made before the court ruled in Shearing. There have been a number of
Okay,
settlements
I just want to say,
recently.
there's no evidence reverse settlements have actually reduced costs.
The chair now recognizes Mr. Stupak for 7 minutes for the purposes of questioning the witnesses.
Thank you, Mr. Chairman. Dr. Sherman, let me ask you this question. In June of 2008, Pfizer reached a settlement with Ranbaxy concerning Lipitor, the world's top-selling drug. According to press reports, the settlement delayed the entry of generic here in the United States until November of 2011, up to 20 months later than many analysts had been anticipating. The settlement of litigation here in the United States was part of a global settlement in which Pfizer granted licenses to Ranbaxy, authorizing Ranbaxy to sell generic Lipitor in 7 other pharmaceutical markets: Australia, Canada, Belgium, Germany, Italy, the Netherlands, and Sweden. The deal was reported to allow Ranbaxy to sell generic in those 7 countries 2 to 4 months earlier than the patents expire. It was also reported that the deal would make generic Lipitor available in Canada earlier than in the U.S. Pfizer also dropped its challenge to Ranbaxy's current sale of generic Lipitor in 4 countries: Brunei, Malaysia, Peru, and Vietnam. Both Pfizer and Ranbaxy said the agreement did not involve any payments. It seems to me that this global deal was full of payments. Under the settlement, market entry for Lipitor appears to have been permitted earlier in a host of countries than here in the United States, which coincidentally happens to be the largest market in the world. So I have 3 questions, if I may. If we pass legislation solely banning reverse payments, will we see more arrangements like this where delayed entry in the United States is tied to settlement of litigation permitting earlier access to generic in markets outside the United States? Secondly,
Won't companies attempt to evade the payment ban by taking the position that settlements outside the United States are not subject to U.S. requirement that settlements reported to the Federal Trade Commission? And third, if the Federal Trade Commission prosecutes them for any such effort, won't the length of time it takes to do so be so long that any opportunity for savings from generic competition really be lost? I ask you to turn on your mic, please.
Sorry. My concern is not only that reverse payments are not the fundamental problem, it's the ability to block other generics by reason of keeping the exclusivity. That's the fundamental problem. But there's no question in my mind that no matter how one tries to stop reverse payments by legislation, not only is it even if it worked, it wouldn't have a significant effect, but it can't work because the creative minds of thieves are without limit. And there's no question that deals can be simultaneously done outside of the United States. And Lipitor is not the only example. For example, venlafaxine, Effexor XR is another example. Some years ago, Teva settled with Wyeth and agreed to a very late entry in the United States, and at the same time they settled a Canadian litigation that allowed them on the market in Canada through their Nova Farm division. So Canadian consumers have had low-cost generic Effexor XR for years, where it's delayed in the United States under 2 agreements that were entered simultaneously, one outside of the United States. And that probably is beyond the purview of the American courts, because the American courts don't have jurisdiction over foreign companies operating abroad, and there's no way to stop simultaneous signature of agreements that appear to be unrelated or that can be said to be unrelated. Also, attempts to block anti-competitive agreements by the FTC taking action will be futile because they'll become moot by the time it's decided. It may be decided after 5 years after an agreement is signed that it's improper, but in the meantime there's no other generic firm, because that agreement is there, able to justify investing to challenge the patent or bring the product to market. So even if a challenge were to an agreement were to work, it would be moot by the time it happened. So the concern that we have is not only that attempts to block anti-competitive deals by banning reverse payments won't be effective, but it's not really addressing the fundamental problem. And that is not the payment itself, but the fact that these deals, whereby the subsequent entrants, subsequent filers who would fight, can't fight because they can't get on the market, that's the problem that has to be addressed. Give shared exclusivity to a subsequent filer who wins. That solves the whole problem. The problem disappears and consumers will get the benefit.
Well, let me ask this one. I'm going to ask Professor Hemphill if he could answer this one. H.R. 1706 only prohibits a very specific type of provision, exclusive payments, in drug patent settlements. That is, the bill only prohibits the brand name drug from paying or providing value to the generic company in exchange for the generic company delaying market entry. The bill does not ban legal settlements in general. History has shown us that drug companies are perfectly capable of settling their patent disputes without exclusion payments. When the Federal Trade Commission and states cracked down on these types of settlements in 2000, they disappeared, and drug companies settled their cases just like any other companies do in other industries. However, when the courts then invalidated the FTC's enforcement efforts in 2005, exclusion payment settlements came back with a vengeance. So, Professor, doesn't this show that drug companies are perfectly capable of settling their patent disputes like any other company? And is there any evidence from the settlements from 2000 to 2005, which did not contain reverse payments, were they any more costly or difficult to achieve than settlements with reverse payments?
So that's a terrific question. It's difficult to get to the very bottom of the question using publicly available information, though based on the work that I've done as to settlements, with respect to the information that's in the public domain, the answer does seem to be yes. That is, just as you've suggested, drug companies during that interregnum when the FTC rules seemed to be in effect did seem able to settle, just not able to settle in an anti-competitive manner.
Right. Okay. Commissioner Rausch, did you find the settlements during this period to be more costly or more difficult to achieve by drug companies during that 2000-2005 period when your enforcement mechanism was there? Okay, anyone else care to comment on that, Ms. Berry? Did your companies find it more difficult or more costly to sell when we did not have that 5-year period of time?
Thank you, Congressman. I would just say that I think Mr. Hemphill is right that the publicly available data aren't sufficient to show that for a fact, and I would.
How about your internal data on behalf of pharma? You must track that, do you not?
No, we do not track the number of settlements each year.
Okay.
Gentleman's time is ended.
Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Nebraska, Mr. Terry, for 5 minutes.
Thank you, Mr. Chairman. I'm one of the, I think, maybe 2 or 3 trial attorneys on this side of the aisle. Omaha, you're right. But wow, I knew there was something I liked about you. And settled hundreds of cases, wrote, read settlement agreements. But I got to tell you, this one's a little out of the box for me, so I'm going to have to kind of take some small steps and ask you some generic questions, pun intended. That's as good as it gets up here, folks. So, Mr. Rush, just so I understand the scope of things, how many, just taking the last 5 years, how many of these reverse settlements have occurred? Are we 5, 10, 500?
At least 103 that I know about, Congressman. Our staff reviewed that many at least, including, I should add, reverse payment settlements in which there were side deals, plus a date certain for entry. So they were not always just payments of money, but there were 103 of them, and our staff found that all but a couple of them were very suspect.
Now, I'm sorry, out of the 103, or you found that 103 of them were suspect?
No, 2 of them were not suspect.
Were not. So 101 of them fell into a category of being suspect.
Correct. And I guess that's why I have some problems with Teva's thesis, because they would like to exempt a lot of side agreements.
Okay. Now, as I understand, when they file their patent, when the brand name files their patent, I mean, there's a date certain there of when that patent ceases to exist and a generic can come in. I mean, that's very easy to find that information, right?
Yes, but.
Okay, what's the but?
The but is that there's also provision in the statute that for a certain period of time after the brand is entered, it will basically get a free pass. Normally that's 5 years, but it can go up to 7 years in the case of some pediatric drugs where there are relatively few sales. In addition to that, they get something that you and I never saw in our lifetimes as litigators, and that is that they get a certain period of stay time with respect to an automatic, if you will, preliminary injunction. And there's nothing like that in any of their patent.
Would that stay time average?
I believe.
And who gives that stay time? That's not statutory.
It's statutory.
That's statutory.
That is.
So statutorily, they get an extra amount of time because of.
It's 30 months.
30 months. So I guess, is there then not clarity on when the date that the patent runs out, that the generic can just jump into the market without legal issue?
No. Again, this is a matter of the statute. The statute allows what is called the first filer, who goes to the FDA first and certifies that it is not infringing or that the patent is invalid.
Well, that's where, can I interrupt there? Because that's where part of my confusion is coming in. If the date for the patent has run out, why do they have to declare or somehow adjudicate that there's something wrong with the patent?
Because the statute contemplates that before the patent runs out, the generic will be incentivized to challenge patents which are not valid or infringed, or in which validity or infringement is questioned.
Well, even though they may be incentive, they still have to find something wrong with the patent.
Correct.
Unless they want to wait until the end of the patent date. So it seems to me that if they're incentivized to attack the validity of the patent because we want to have a policy that gets those generics out there sooner than the end date,
yes,
I'm not sure if I would agree with the premise that these are reverse payments. Out of the 103 then, let me just jump to my conclusion for my last, I'm out of time, but
surely.
let me ask this question. How many out of the 101 nefarious reverse settlements actually made the date that the generic got to the market sooner than the clear date that the name drag patent ran out?
The answer is, I believe, in almost all of those cases, it was sooner, but I would suggest most respectfully that that is not the question. Brand names do not pay tens or hundreds of millions of dollars in reverse payments to generics in order to accelerate their entry into the market. They don't do that. What instead they are doing is they're paying to keep that, to skew, if you will, the incentives of the generic to prevent the generic from actually challenging a patent that should be challenged. So that is the pernicious part. There's nothing wrong, I want to emphasize that, there's nothing wrong with the incentives created by Hatch-Waxman. The problem is created by the reverse payment settlement.
The chair now recognizes the gentlelady from Illinois, Ms. Schakowsky, for 5 minutes.
Let me just say that over 30 years ago, I was involved in, because I was a director of a senior citizen organization working to get the state of Illinois to pass generic drug legislation in the hopes that it would reduce the costs, which has proven to be true. My colleague and friend, Mr. Stearns, was talking about how incredible it was that the generic drug, or at least the first filers anyway, and the pharmaceutical companies were on the same side. Obviously, the problem is that they are, because both are benefiting to the detriment, it seems, of the consumers. Mr. Whitehouse, you were proudly citing this the study, and you certainly didn't mean to imply that because Laura Tyson was an author that the Obama administration is supporting this point of view, did you?
Not at all.
Okay. And who paid for this? And who paid for this study?
My understanding is that funding was provided by Ms. Bierry's Association Pharma. But they make clear that they express their independent views.
I just think that's important to note for the record, that the study that's being cited was paid for by the pharmaceutical industry. Dr. Sherman, well, actually, let me ask the Commissioner Roche. Is it Roche? I'm sorry.
That's perfectly fine.
What is it really, though?
Rush.
Okay, Rush.
Like the chairman's.
No, you should accept your real name. Okay, Rush. The suggestions made by Dr. Sherman, he proposed that maybe we would consider 2 amendments to the legislation. Do you or Mr. Hempel, if you want to comment on that, think that would improve the legislation, and why?
Well, again, I'm just speaking for myself, Congresswoman, but I am very reluctant to reduce the 180-day exclusivity period, or to water it down at all, or to dilute it at all, because I think that is the carrot. That's the incentive for the generic to challenge.
Okay, but if the first filer makes a deal, and then the second filer, well, maybe you can explain it better, Dr.
That's why I want to ban reverse payments, because that...
Period.
Period.
Okay.
I'm-
But why is your suggestion preferable than Dr. Sherman?
Because we're not suggesting that the 180 days be reduced. We're suggesting that it go to or be shared by the person who actually earns it, the one who actually carries the challenge and succeeds in invalidating the patent. Right now, the first filer can settle and keeps the 180 exclusivity, which is a huge reward for doing nothing, for agreeing not to challenge a patent, and for agreeing with the brand company to defer generic entry until just before patent expiry at enormous cost to the consumer. They're not earning it. So we're saying in a case where a first filer has settled, it's not entitled to that exclusivity, but let them keep it anyway. Let's just give a shared exclusivity to the person who then picks up the challenge, does what Congress intended, invests in challenging the patent, and succeeds. If you don't do that, there's no incentive for anybody to pick up the challenge and to get early entry into the market in the face of a settlement by a first filer who's agreed to undermine the system and accept very late entry.
Mr. Hempel, does that make any sense?
So the underlying policy concern is a real one, that a first filer could settle, retain the exclusivity, and that would create public policy problems. Perhaps a simpler solution, a solution actually suggested by Apotex 2 years ago, would be that upon settlement, the exclusivity is simply forfeited. My concern about adding a new layer of exclusivity, in addition to the possibility of diluting existing incentives, is this is an extremely complicated scheme as it is. A lot of the problems result from manipulation of the 180 days. Doubling the set of possible or multiplying the set of possible holders of exclusivity, I think promises some confusion and complexity. The forfeiture alternative, which Apotex in the past suggested in response to the same policy concerns, strikes me as a simpler and maybe easier to implement alternative.
May I answer that? We did propose that 2 years ago, and it certainly would be better than what we have now, simply a forfeiture of exclusivity. But the problem there is then there is no incentive for a subsequent filer to take up the advantage, to take up the battle, and that is the very thing that the whole regime is intended to incentivize. So giving a shared exclusivity to a subsequent filer who does take up the battle is better, because then you're going to have someone investing to do it, and that will result in earlier entry into the market for generics. It's very important.
I appreciate this back and forth. Thank you.
The chair now will recognize the ranking member of the subcommittee, Mr. Radonovich, for 5 minutes for opening round questions.
Thank you so much, Mr. Chairman, and I beg the forgiveness of the committee. I had a prior constituent water issue that needed to be addressed. I'm a little bit late to this hearing. But I want to thank the panel for being here. I do have a couple of quick questions. First of all, to the Honorable Mr. Rush. Ms. Handy testified that H.R. 1706 creates two safe harbors. The first, that the only value allowed for a generic is the right to market a drug prior to patent expiration. Second, the generic cannot be sued for infringement, thereby insulating them, from any damages. A settlement is usually an agreement where both parties receive consideration. However, it seems that the considerations are entirely one-sided. What would be the benefit to the brand company to settle in this situation, number one? Number two, why would a brand company ever choose not to prosecute their patent to the fullest to see litigation through to the bitter end?
Well, with respect to the first issue, I think it really goes to whether or not side agreements should be or are covered by this legislation. And the answer is, as I indicated earlier, based on our own studies internally, side agreements can indeed end up being a part of the problem. So that's the answer to the first part of the question. The answer to the second part of the question really goes to the extent to which you want to incentivize, it seems to me, you want to incentivize the generic to actually challenge what may be an invalid or a patent that is not being infringed. And again, my view is that you want to give my my own personal view is you want to give the generic the the broadest possible incentive in that regard, which is what I think you do with the 180 days.
Thank you very much. Ms. Beery, is it? Ms. Beery? Thank you. Why is it so important for innovative pharmaceutical companies to retain the ability to settle patent litigation with generic companies?
Thank you, Congressman. Litigation is risky and expensive, and it incurs significant costs for both the brand companies and the generic companies. Companies have to have a way to resolve their disputes without taking them the whole way to trial. And so for both parties to this litigation, it's important to have the flexibility to be able to come to mutual arrangements that are still within the scope of the patent and therefore beneficial to consumers, and ultimately which will bring these medicines, generic medicines, to the market before the patent expires, but still be a fair arrangement for both parties to the settlement.
Wouldn't it be better, wouldn't the brand companies be better off if they successfully defended their patents in court?
That would be true if, in fact, the outcome of litigation were always certain. But litigation is risky, expensive, and uncertain, and businesses like certainty, as you well know. So it's often better for the brand company to, within the scope of its patent, have a date certain by which it knows that the generic will come on the market.
I see, yeah. Question for the panel, anybody who cares to respond. Our government and our American companies engage in daily fights against intellectual property theft. It seems, however, that a number of our witnesses are arguing for less stringent IP protections when it comes to pharmaceuticals. I think that we could all agree that life-saving innovation must be encouraged, but it seems, however, that you're arguing that the IP rights of some innovators are less worthy of protection afforded by the law than perhaps Hollywood or Silicon Valley or Nashville. Many can defensively disagree, but I'd like to hear any of your thoughts on the issues of intellectual property in general. Mr. Hemphill?
Yeah, I guess just to start, I think it's not true at all that the proposed bill here runs any risk of treating pharmaceutical companies, brand or generic, as second-class citizens. As matters stand, we have a very complicated regime that's already very different from what anybody else gets. Commissioner Roche mentioned a few moments ago the special 30-month stay granted to a brand name firm, even if the patent is extremely trivial. Patent term extension, of course, is another example. There are examples on the other side, but to think of this as an example of second-class citizenship for pharma companies, I think is far from the fact here.
All right. Anybody else care to comment? Mr. Sherman? Doctor?
But what distinguishes pharmaceuticals from other industries is this unique provision whereby the first filer has exclusivity to block others. So what you have when you have under this regime, a brand company and the first filer negotiating, the parties that are not at the table are the public and the other generic firms who would be prepared to continue to fight. And the settlement, to which they're not a party, affects them because it precludes the other generics from fighting to win because they're blocked by the continuing exclusivity. And the consumers aren't at the table, and they're the ones who are paying the billions of dollars of extra money as a result of the settlement. So, sure, this bill would treat pharmaceuticals differently because it would ban reverse payments. But the question that should be asked is, why are they happening in this industry? And it's happening because the present regime permits a first filer to settle on behalf of all of the generic industries and consumers who are not at the table. So the way to fix it is not to have special provisions that bar reverse payments, but to fix the regime so that a first filer who settles is settling only for himself and is not blocking another generic who would in fact continue to invest and fight for earlier entry.
Gentleman's
Thank
time
you.
is concluded.
Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. First question, just open up to the whole panel. If you can explain or give an example of a case where Congress has actually specified that a certain industry-specific private settlement would be illegal. Start with Mr. Whitehouse and work down.
We're certainly not aware of any, and we think, in fact, it is important to recognize, and these economic papers do point out, make the important point, that this isn't unique to pharma, that every settlement in any litigation, as any litigator will tell you, involves some mutuality of consideration or there wouldn't be a deal. And so it is the technicality of how the money or the compensation moves in any particular transaction. It's really an artifact, but it's not in the end of any interest, because a settlement is not going to happen unless both sides are getting something out of it.
Thanks. Mr. Sherman?
Well, again, the problem is that this industry is unique because the first filer in this case who settles is settling on behalf of everybody and entering an agreement which blocks all others from getting to market. That is what distinguishes this industry, and that is what is wrong. That is what should be fixed.
Do you know of any other cases in other industries where this type of proposal that's brought forward is?
No, because there's no other industry where somebody gets an exclusivity by reason of doing a challenge and can block all others. That is the problem.
Not sure that that's the case, but Ms. Beery?
Congressman, I'm not aware of any other industry in which a bill targets settlements of a particular type. I would say that the courts, when they look at these, and to some extent the agencies, have approached these as on a case-by-case basis, so that they start from the proposition that settlements are pro-competitive if, in fact, they would allow the generic to enter prior to the expiration of the patent, and if, in fact, they don't, then they may be anti-competitive. So they pursue a case-by-case analysis, which to us is more sensible than a per se ban.
Ms. Handy?
Respectfully, Congressman, I don't know the answer, but I think whether or not it occurs, the issue is whether it is good for consumers.
And then we'll get into that later in the question. Thanks, Mr. Hempel.
Yep. The litigation, the settlements, and the proposed fix are all industry-specific and unusual.
Unusual. Thank you. Mr. Rush?
That is correct.
All right, well, thank you.
But
First round, well, let me ask Mr. Rush
as has been
then,
pointed out, however, Congressman, this industry is very unusual as well.
I'm sure, and many are in their own rights, many industries. According to your reports on settlements, there have been over 50 settlements filed with the FTC in the last 3 years. Your testimony, I think, said a large number of them have side agreements, yet of those 50, the FTC has not filed legal challenges against any of them, and private plaintiffs have brought suits against only 2 of them. Why has the FTC not challenged any of those settlements?
It's quite simple, Congressman. We're trying to pick those settlements which we think are most pernicious and we think we can win. We want to win one of these cases because we feel that we're not only the guardians of consumers in this fight, but also the guardians of you folks who enacted Hatch-Waxman.
So I guess that means you don't feel you could have won the other ones that have been filed.
No, I don't mean to leave that impression. What I do mean to leave is the impression that the ones that we've challenged, we think are the ones that are most obviously pernicious to consumers and most violent.
But obviously you make a calculated decision then if you don't, you only bring a suit if you feel that you can win.
No, that's not necessarily
But
so.
that's
I mean,
what
if
you
we
just
had
said.
unlimited resources, we'd probably be challenging all of them, but we don't.
Well, the same is the case with the generic company that brings a case to court as well. They don't have unlimited resources either, but obviously they feel they've got merit, and that's why they bring the case, and then this bill would remove their ability to settle. Several settlements, including those involving Prozac and tamoxifen, have saved consumers and taxpayers billions of dollars. Looking back, do you believe such settlements were anti-competitive merely because they contained some type of settlement, or reverse payment, as you call it?
Do I think that tamoxifen and
well, do you feel that those settlements were anti-competitive? They were legal. They would be illegal under this bill, yet they did save consumers billions of dollars. So how do you justify trying to take away that ability to save consumers billions of dollars, as has been the case in past settlements?
We certainly thought tamoxifen was a bad settlement, that we thought that was an anti-competitive settlement, and we saw nothing, no data, whatever, that would suggest to us that it saved consumers billions of dollars.
Mr. Whitehouse, I know I'm running out of time. Experts have testified that collateral agreement side business deals like these licenses are co-promotion agreements on products unrelated to the patented product in dispute can help the litigants in a patent suit bridge the gap and reach a settlement on patent litigation. Have you experienced that? You've taken some of these cases before.
Yes, absolutely. That is crucial to the point that we've made in our testimony, is that the ability to reach these settlements and bring these products to market sooner in cases that we must not forget we could have lost. I mean, everybody sort of assumes that we didn't settle, we would have won. It is very important to remember that something else we could have lost, and the consumers would have been denied any benefit until the expiration of the patent. And so the opportunity to come up with these alternative or additional terms that enable the parties to bridge their different perceptions of the case, bring about a settlement that, on average and typically, will bring these products to market sooner for the benefit of consumers.
I see I'm out of time. I yield back.
Chair now recognizes Dr. Gingrey for 5 minutes.
Mr. Chairman, thank you very much, and direct my question to Commissioner Ross. Commissioner Ross, I think you've been very forthright in your response to the questions throughout the hearing. Having said that, I guess you are anticipating that I'm fixing to blast you.
Yeah.
Not really.
I
but
call it piling on.
Yeah.
But that's fine.
But in a number of ways, I do find your testimony to be counterintuitive. You say that the reverse payment settlements negatively impact consumers by delaying entry of generic drugs to the market. Based on the testimony of the other witnesses, many times these reverse payment settlements, they actually allow the patent holding company and the generic company to negotiate terms by which the generic can begin being marketed before the expiration of the patent. Presumably, because of the unique nature of patent law in this area, the settlements actually help consumers, it would seem to me. But then, what then is anti-competitive or anti-consumer about this kind of settlement? And before you respond to that, a quick second. I think it was Mr. Radonovich that was asking you about the question about side deals, and you may have talked about other consideration in a settlement, not including reverse payments. But my concern,
payment of dollars, you're correct.
Yeah, but this bill, as I understand it, would prohibit any of that, not just dollar payments, reverse payments, but any other side deal. So if this bill passed, then what incentive would the brand name company have to settle? Certainly, it would appear none whatsoever to negotiate with the generic. So, 2 questions, and go ahead.
Okay. I think you're correct about the bill. As I read it, it would indeed go to side deals as well as to direct payments of money. As I said before, that doesn't really trouble me because our staff has taken a look at these agreements, including side deals, and they have concluded that except in a very small number of instances, those side deals are anti-consumer and they are anti-competitive. And incidentally, Congressman, there's nothing at all unique about banning this kind of deal within the context of a settlement. The United States Supreme Court said that an anti-competitive aspect of a settlement agreement could be struck down as per se illegal many, many years ago in the Singer case. So this is not brand new. But let me get to the sort of the first part of your question. Why, I ask myself, if indeed the effect of a reverse payment settlement would be to stifle entry, early entry, to delay early entry, why are these deals occurring? And we are seeing them. Why is the brand willing to pay, as I say, millions of dollars in these settlements? And I would suggest to you that the reason is to delay entry because the brand is enjoying patent monopoly profits and prices. It's kind of as simple as that. Now, should we be litigating these cases on a case-by-case basis? I would suggest to you that we should not. There is already in the bill sort of a safety net, if you will, in our rulemaking authority. If we find that some of these deals that we shouldn't be challenging them on a case-by-case basis, we can carve those out as a safe
Yeah.
harbor.
Commissioner, reclaim my time, and I'm down to 45 seconds because this is
I didn't
kind of a
mean to
segue.
run down.
No, I appreciate your response. Segue into my question that I wanted to ask Ms. Beery and Mr. Whitehouse. As representatives of pharma and the generic drug companies respectively, you know through practical implementation that both the FTC and the Department of Justice already have the ability to challenge any settlements that, and I think that's what the Commissioner was about to say, that are anti-competitive and thus harm consumers. If the blanket ban on settlements in H.R. 1706 is implemented, what incentive do your respective industries have to settle patent litigation out of court, and how would that affect consumers?
Thank you. I'll begin by saying that I think because litigation is risky and expensive, I think there would still be incentives for companies to try to settle patent litigation even if H.R. 1706 were to pass. Unfortunately, the options for them to do so are what would be very limited. And so you would be left in a situation where the brand and the generic company would be only able to negotiate over the date of entry for the generic. This is the heart of the patent dispute, and obviously the parties are going to have very different views on that point. And so in many of these cases, we think that they would be unable to reach an agreement, and the case would then have to proceed through litigation. And recent statistics show that in most of those cases, at least the majority, the brand company would ultimately be able to defend its patents, and so generic entry would be delayed.
And if Mr. Whitehouse, Mr. Chairman, if you bear with me, if Mr. Whitehouse can respond to that question as well.
Yes, Congressman. And the important point to focus upon here is that if you make it harder to settle, you're going to reduce the incentive to bring these cases in the first place. And if the whole point of Hatch-Waxman was to precipitate litigation over doubtful patents and bring generic products to market sooner, if you diminish in any way the incentive in the generic companies to initiate those litigations, which is an inevitable consequence of making it harder to settle them, that is inherently anti-consumer and undesirable, and that's why we're opposed to this mechanism.
The chair initially offered that we will go into a second round of questioning, but there is a vote on the floor, and in light of this fact, then the chair will call this subcommittee hearing to an adjournment. But before he does that, he wants to make sure that the witnesses recognize the fact that we are indebted to you so deeply because of the investment of your time into this matter. You have really shed some tremendous light on this issue, and we will be referring to your statements, both pro and con, for the duration of this legislative process on this particular matter. I just want to also alert you that we ask that you should be prepared to receive and respond to written questions submitted by members of the subcommittee. And I want to, for the records, to remain open for 10 days to receive additional statements. And the final matter is that the ranking member of the subcommittee, Mr. Radonovich, has an opening statement that he wants placed into the record, and with hearing no objection, is so ordered. This subcommittee is now adjourned. Thank you very much.
Thanks, Bonnie.
Thank you, Mr. Chairman.